All right, welcome back to the KFYR Plus News Desk. And California's new SB 918 law opens the door for law enforcement and insurance investigators to access social media like never before. Personal injury attorney Michael Avanesian now joins us to explain how your posts now could be used against you. Welcome to the News Desk, Michael. I appreciate your time.
Hi, Jay. It's Lem Garcia.
Oh, Len Garcia. Why do I have Michael? So, Len Garcia. Let's write that down. My apologies to you, Len. Here we go. So, Len, what exactly does
Sorry, it's Lem, Lem.
LM? There we go.
Yeah.
Thank you, Lem. Okay, so Lem, what exactly does SB 918 require social media platforms to do, and how does this change law enforcement's access to user data?
So law enforcement now, they have a 24/7 hour hotline essentially with social media companies to request information from them. They still have to meet probable cause and have a search warrant, but now they have easier access to social media platforms like Instagram and TikTok, requiring them to give up information within 72 hours essentially.
Okay, so does this new law in California allow law enforcement to access private posts, or is it limited to just the public content? Because let's take, for instance, Facebook. You can allow public see posts, or you could allow just your friends to see a post.
Yeah, good question. So it opens it up from not just public posts, but also private posts as well. So anything that you post online, whether it's public or private, law enforcement now has access to those images, videos, or even just regular posts to find out what you posted.
And how are insurance companies going to be using this social media possibly to use it, maybe to say to deny injury claims?
Well, insurance adjusters and defense attorneys, they use social media to essentially diminish the value of your claim or just essentially defend the case, delay payment, and hurt your case. They want to say that you're not hurt. They want to say that you're faking it. And quite frankly, insurance adjusters, defense attorneys, they love social media more than teenagers do. They love to get free evidence. They don't have to follow you around anymore. They can just pull up your social media and find out what you're up to and take those photos out of context, take those videos out of context and say that you're not hurt, that you're absolutely fine, even though you're just, enjoying life.
Yeah, I want to go back to the private content thing. I got one more question on that, Lem. How does it define the private content? Can law enforcement access your direct messages between, let's say, you and I, or how about deleted posts? Can they do that with a warrant?
It definitely opens it up to that. I think it's still yet to be seen how that works out, but I know that it opens it up your private messages and your private posts to law enforcement.
Okay. What are some surprising platforms people don't realize can be used against them, like maybe fitness apps, or how about payment apps?
Yeah, those apps. I mean, I think when you use those apps, the fitness apps, it tells the public how active you are, how many miles you ran, how active you were for that day, how many miles you walked. So the insurance adjuster will use that information, say, "Oh, you walked 3 miles today. How did you do that? If you were in pain, you've been seeing a doctor for so long, you have back pain, you have neck pain. How are you doing these things?" The apps like Venmo that show who you're paying and how much you say, okay, activity, I went bowling or I enjoyed a nice night out dancing. It's like, well, how are you doing those things if you're injured? And even if you just sat on the side and you went to the bowling alley, but you didn't bowl, it still looks like that you went bowling while you have back pain.
Wow, it's just amazing. So, what are the top three things someone should avoid posting on social media after, let's say, they're filing an injury claim, Lim?
Well, I think it's really simple. Don't post photos, don't post videos, don't post comments. Essentially, don't post anything. Just go dark because anything you say can and will be used against you. The insurance adjusters and defense attorneys are just looking for any kind of evidence to say that you're faking it when even though you're seriously hurt.
Would it be wise if you were to file a claim to, like you said, just go dark? Maybe not use, maybe you can keep your social media platforms, but just don't use them, or maybe put them off to the side and, like I said, don't use them whatsoever.
Yeah, I would recommend just stop using it. I wouldn't say to delete your accounts and go that far, but you can definitely just stop posting, and yeah, just avoid it for now. Your claim could be open just, not for that long. You can hold off posting for a little while.
Okay, so we understand that they have access now to social media posts, your Instagrams and your Venmos and stuff like that. Okay, what about your phone? As you said, what if I'm driving out to the bowling alley and I'm not again bowling, but I'm there at the bowling alley, and then I drive to Applebee's and maybe I get a burger to go, their 2-for-1 deal, right, with the kids or something. Can they access my phone?
This bill doesn't go that far where they can just access your phone. This bill just is specifically for social media accounts, and it's even just social media accounts that have a lot of users. So I wouldn't necessarily go that far where you're worried about every action that you do take.
Okay. Do you see any privacy or constitutional concerns with this law in California, SB 918?
I do see that there's an issue that, you know, the more accessible photos and videos in our social media becomes, it will have a chilling effect on personal privacy, and we will feel like, every step that we take is being monitored, and we will feel like, all the things that we can post and share with our friends and family, like, we can no longer do, and it just kind of erodes the trust. And I feel like there's a concern of just chilling that, our personal privacy.
Do you think this could set a precedent for other states now? California, the first now. Could this just roll on through the other 49?
Absolutely. I think there's been precedent where a lot of things that California does, other states are soon to follow. So, I think California was one of the first states to ban smoking indoors, and a lot of states soon followed afterwards. Or, we have plastic straws in California, and a lot of states followed afterwards on that. So I think, yeah, this is just the beginning.
Are there any legal recourse for someone who feels that their social media was unfairly used against them? As you mentioned in an example earlier, if you just go to the bowling alley and you're just sitting there watching your kids.
Well, as far as cases go, if you feel like your information was illegally obtained, that information would be inadmissible, or arguably inadmissible in court, so that at least that evidence wouldn't be used against you.
Okay. Given the growing role of social media in legal investigations, what final advice, Lem, would you give to anyone who's active online and might one day face a personal injury claim?
I mean, after you've been injured in an accident, make sure that you just stop posting online. And then on top of that, just tighten your privacy settings. And then also, in addition to tightening your privacy settings, just if you get any kind of friend requests or comments, just ignore those for the time being.
Yeah, Lem Garcia, Big Brother is following us, isn't it, everywhere? So thank you, sir. I appreciate your insight on this very important topic.
Of course. Thanks, Jay.
You bet. All right, 12:39 here at the news desk. We'll take a quick break here. We'll be right back on KFYR Plus.